We are here now to talk about pay equity and transparency here and abroad. So please welcome our panelists who are going to introduce themselves to you.
Hi, good afternoon, everybody. My name is Joy Chen. I'm a principal based in the New York metro area of Jackson Lewis. We're a national law firm representing employers in all aspects of workplace law. And I'm also co-lead of our Pay Equity Resource Group. I am delighted and honored and a little bit daunted to be joined on this panel by Michelle Caiola. Michelle's a partner at Phillip & Associates. They represent plaintiffs in employment discrimination and sexual assault matters. Michelle actually began her career as an attorney for the EEOC, where she led high-profile glass ceiling sexual discrimination suits, including one against a very large multinational investment bank and financial services company, alleging systemic pay disparities. Later on, Michelle was litigation director at several feminist nonprofit organizations. But truth be told, her fearless advocacy began long before that. While she was in college, she was arrested on the steps of the Supreme Court for protesting. So, needless to say, I am glad I'm sitting on the same side of the table right now as Michelle. I'm also joined by Nikki Carusone. She's an industrial organizational psychologist and senior consulting scientist at APT Metrics. She holds a PhD from the University of Central Florida, and she consults with client organizations in numerous industries on HR practices, such as development and validation of selection procedures, performance management, job architecture, and compensation. Nikki also consults on pay equity and other employment discrimination matters in the context of settlement agreements and as an expert witness, as well as in a proactive capacity. And in her spare time, right, Nikki, outside of work, you can most often find her sitting at a coffee shop with her rescue dogs. And then rounding out our panel is one of Germany's leading labor and employment attorneys, Daniel Hund. Daniel's a partner at CITES. It's a Tier 1 firm representing management on German labor and employment law, where he oversees the firm's international relations. His specialty is strategic and tactical advice on major restructuring projects, complex litigation, compensation schemes, and negotiating with unions and other employee representatives. Daniel holds a JD from Heidelberg University and a Master of Laws degree from NYU. So welcome home.
He's my former student. I take credit for all of his successes.
Daniel's a founding partner of CITES' Munich branch and shares his downtown office most of the time with his chocolate lab retriever, Tony. Did you bring Tony?
No. It's too expensive to have him on the plane.
So today we're going to talk about the rise of pay equity and transparency laws, the impact that those laws have had, right? The legal landscape today, and then what lessons we've learned or what we should be doing differently, right? We are going to take questions at the end, I promise you. If for some reason we cannot get to all of the questions, I think we're all staying here until the end and are happy to have a discussion, all right? So you just need to find one of us. All right, so it's been 16 years, believe it or not, right, since pay equity was thrust into the forefront. Right? 2009 began the first term of the Obama administration, and closing the pay gap was a major initiative of that administration. In fact, I'm sure you all recall the first act that was signed by President Obama, the Lilly Ledbetter Act, right, that extended the statute of limitations to bring a pay discrimination claim. And at that time, we saw some grassroots movements, right, towards encouraging employers to voluntarily disclose pay information, right? At local and state levels, we saw initiatives such as the Boston Women's Pay Compact. There was an equivalent out on the West Coast, and there was even one at the White House, right? And that site has long been taken down. But interestingly, pay transparency movement didn't really gain traction, right, until the first Trump administration, right, in 2017. And at that time, we saw the UK, right, enacted a mandatory pay reporting law, right? The EEOC then attempted to implement something similar. I'm sure you all remember EEO-1 Component 2 pay reporting, right? But that got tied up in litigation. We saw where that ended up, right? It was ultimately discontinued. But it really took a confluence of events, right? The Me Too movement, the social justice, Black Lives Matter movements, and the pandemic to reinvigorate this push on corporate America to be more open about pay and to focus, again, refocus on closing that pay gap. So we saw more and more corporations during this time begin to volunteer workforce demographic information, pay information, right, committing to make change. And then we also saw a flurry of public support, right? We saw celebrities, we saw professional athletes, even the Pope at the time, right, spoke out, and there was very public litigation, right, both the U.S. women's soccer team and U.S. women's hockey, right, and there was continual media coverage. So a lot of things happened, right, that brought about this rise in pay equity and transparency laws. But Michelle, was there any real change in the legal framework as a result?
So no, I think that maybe is the good news. But generally, we have a few laws at the federal level that are meant to combat pay discrimination. Excuse me. And then also at the federal level, we have agencies that are set up as the watchdogs to try to enforce this as well. I would say Joy just talked about the recent movement, but this started in the 1960s. President Johnson signed several laws in a row and had an executive order that could be used to fight for pay discrimination. And this was a civil rights era, and that's 1964 is when the Civil Rights Act started, and of course Title VII is the one that prohibits discrimination in employment. And I think it's interesting to note that we have this dual part to enforce these laws, and one would be the right for private lawyers to go right to court and enforce them, and one for the agencies that can also act on their own, can investigate, et cetera. And I would actually say we have a substantial legal framework, and I'm not sure I would have said that before talking to Daniel and hearing about what other countries have. But we have our laws, and the agencies really can enforce that, but they don't necessarily, the agencies don't have a role in what private attorneys are doing. They more have a role in overseeing whether companies are discriminating on their own in their own capacity. So, you know, one that was before the civil rights movement that's helpful in terms of pay equity is the NLRA. And they set up the NLRB, which you've heard a lot from today, but that's not a specific pay equity statute. But it does provide for the right to discuss wages with your employer, amongst, you know, your colleagues. And I don't think, it's hard to work on pay equity if you aren't allowed to talk about it, and if you can be fired for talking about it. Maybe we could, yeah, sorry. So I have some slides that set out these main laws. I'm not going to go through them. If anyone wants to talk about the intricacies of each, feel free to find me afterwards. But the National Labor Relations Act was more about fair wages and about safe workplaces, et cetera. It gave employees the right to unionize and to collectively bargain, et cetera. And as I said, that's an important foundation to be able to move towards pay equity. Another piece, and something that President Johnson put in place back in the 60s, was Executive Order 11246. And this set up the watchdog agency of the OFCCP, Office of Federal Contract Compliance Programs. And I will say more about this later because it's not really in existence at this point, at least for pay discrimination. But this is only a small piece of pay equity because the executive order only affected federal contractors and the subcontractors. So if you were doing business with the government, we had a framework to watch that you were not discriminating because that was against our mission in the government to support equity. They even had a component which will obviously be very controversial, which was to have an affirmative action plan. And this is the only one I know which had this actually in the order, but that has been rescinded as well. The major watchdog group for pay equity laws, though, is the Equal Employment Opportunity Commission, the EEOC, and they basically, at the federal level, oversee all of our anti-discrimination laws. And they, too, have mechanisms. All these agencies have reporting requirements, investigatory roles. They have subpoena power and usually can take these claims to court or to a hearing. But the EEOC oversees the Equal Pay Act as well as Title VII, the Civil Rights Law, and both of these specifically prohibit pay discrimination. So it's right on point. The Equal Pay Act's interesting because it was signed before Title VII, and it only allows for claims to be brought if it's sex-based inequities. I don't see this used very often for various reasons. And then Title VII of the Civil Rights Act is really where most of the action is, I think. And as long as you have 15 or more employees, Title VII covers both public and private employers, and there are broad damages under this statute, back pay, front pay. So this is I think, part of the impetus for the plaintiffs' bar and the growing numbers of us plaintiff attorneys who are doing this work, because these cases have value, and both for our clients, but also to be able to sustain a law firm, et cetera. So this is a really important piece, but I will emphasize too, we have these agencies. Those shouldn't be affected. Our private laws shouldn't be affected as well. As far as the private plaintiffs' bar, we go to court under these same laws, and nothing has changed. But for the agencies, there have been some changes, and I think we're going to talk about it a little more. But for about 70 years, these agencies hadn't been changed. But now there are some additional considerations and changes.
So I think it's fair to say that there was no real change, right, in terms of the federal statutory framework.
Great.
All right, and we'll talk about it in a little bit. What we'll see is probably more in terms of how those laws are enforced. I think during this time frame where we saw the real statutory sea change, right, was at the state level. Right, early on, we saw more state equal pay legislation, but few transparency pieces. Right, so in addition to the federal laws that Michelle just discussed, every state and some cities and counties, right, have their own employment discrimination laws that encompass pay discrimination claims. All but 5 of those states also have separate equal pay laws, all right? And the early pay transparency aspects built into those laws were similar to what we saw under the National Labor Relations Act, right? They prohibited employers from doing something, right? You couldn't take action against employees, right, for talking about or discussing or asking about pay, right? And employers couldn't, right, ask applicants what their salary history was. They didn't quite mandate the employer to do something more proactively, right? And I think with the lack of an overarching federal pay transparency law in the United States, it led to more state legislation. And what we saw and we continue to see is an ever-evolving hodgepodge, right, of state and local laws crop up around the country, right? More than 20 states, counties, and cities have some form of pay transparency law in place, or it's pending, all right? And these laws range, right, in how transparent they are, right? Some require employers to disclose pay information, but only after a triggering event, right? An employee, an applicant asks for it, or an interview's been completed, or a job offer is made, right? To the more aggressive forms, right, that mandate employers be much more proactive, right? And that includes in-job advertisements, salary range, and other compensation information, right, to filing pay data reports, right? California, Illinois, Massachusetts recently tried a pay reporting system, but they defined what you had to report based on the former EEO-1 Component 2 pay report, which doesn't exist anymore and is totally off the books. So basically in Massachusetts, you're really just filing your EEO-1 report without pay data, but they tried. We probably will see that change. But the takeaway from all of these laws, and I'm not going to go into all of them because you will see, we would need an entirely different session for that and much more time, right, is that these laws are similar, but they are not the same, right? So it is causing a great deal of focus, right, and confusion for nationally based employers who may be recruiting across the states. But Daniel, I'm hoping that you can tell us that there's more consistency in the EU than in the United States.
Sorry to disappoint you, Joy. But I'm afraid there isn't. First of all, thank you for having me. It's good to be back, and thank you, Professor Estreka, for this invite. We have the same issues in Europe in terms of the gender pay gap. And we heard some statistics yesterday here during a very interesting panel on workforce economy. And those numbers in terms of gender pay gap could be the same as in Germany and France and Italy or in the whole European Union. It varies a little from country to country, from member state to member state of the European Union, but the general thing is the same. And apparently the reasons for it are also quite similar. What we do have in certain member states of the European Union is various kind of laws. We have in France, for instance, obligations to report. We have a similar situation in Italy. In Germany, we have since 2017 a law that entitles employees to get information about what comparable employees receive as a salary so that they can eventually maybe sue the employer or claim the difference. I can tell from my own practice, and this is Germany, and I have a very broad practice with the bread and butter employment law as well as the big restructuring projects. I have never, ever seen a case in my practice in terms of this law, right? It's really nice on paper, but apparently it doesn't play a big role so far. So in order to harmonize things, as you know, the European Union is not a real state, it's not a nation, it's not a federal government, but it's no association of member states either. It's something in between, and it comes from a free market history and a common and a shared market history, and there are some efforts and some efforts to harmonize situations in this common market. And the European Union, while it's not a federal government per se, they have some jurisdiction over some topics, including employment laws. However, they cannot really enforce and enact laws that directly apply in each member state, but they can set a framework, right? A framework providing for minimum standards that then has to be transposed by each member state into national law. And the European Union has done so in terms of the Pay Transparency Directive, that's what it's called. And it provides for reporting obligations, information rights, but also sanctions such as damages. It requires the member states to impose laws that provide for a switch of burden of persuasion. So if the employer cannot demonstrate that the employer applies a compensation scheme, that prevents discrimination on the basis of gender. Then there's indication for discrimination, and then the employer has to prove and to make their case and to persuade the courts that pay disparity is not based on gender. So far, so good. That's the legal situation. I think we're going to talk about enforcement measures a little later, right? But I don't want to spoil it, but I'm afraid I will have to disappoint you as well, right, when it comes to that.
All right. So I think everyone would agree, right, that being more equitable and transparent, right, conceptually is the right thing to do, but while these laws have been well-intentioned, what real impact, right, have we seen from these laws? Look, if the purpose of these laws were to close the pay gap, right, has the needle really moved? According to a recent Pew Research Center analysis of median hourly earnings of full-time and part-time employees, the gender pay gap slightly narrowed in the U.S. over the past 20 years, right? It went from 81% in 2003 to 85% in 2024. It narrowed considerably when you go back even further, right, looking over a 40-year period from 1982 to 2024. Right. We saw smaller progress, right, in the racial pay gap, according to Bureau of Labor Statistics data, right? The gap for black workers shrunk by about 4 cents on the dollar, and the gap for Hispanic and Latino workers shrunk by about 9 cents from 2000 to 2023. Right. And I understand yesterday, right, we've heard, right, that there's a variety of different contributing factors, right, to the pay gap. It's not enough to have these laws in place, but there are a lot of societal and economic factors that play a part in contributing to this pay gap. But from a practical perspective, right, when we were all discussing this, I think the real impact of these laws that we've seen as practitioners has been at the enforcement level, right? As Michelle mentioned, the federal laws haven't changed at all, but we saw increased enforcement during this time, right? We've seen enforcement of the state laws. I'm just going to chat about that for a second, particularly those job ad pay range posting requirements. But that enforcement really has been, right, based on fines, right? Employers are fined if they don't comply with those laws, right? So that leads to public shaming. In Colorado, they publish employers, right, the list of employers who violated the laws, the amount of the fine. It's also led to increased private plaintiff litigation in particularly Washington State, where that statute allows for a private right of action. And the real life impact there is that it's turned into a cottage industry for plaintiffs. Our Seattle office is handling a number of those lawsuits. My understanding, it's the same 2 law firms and the same 2 plaintiffs who keep filing claims based on the violations of those laws. The good side, right, the upshot, is that I have seen, and I do believe, that employers are being much more thoughtful, right, about how and what they pay their employees, right, because of these laws. Is that necessarily changing the pay gap? Maybe not immediately, but hopefully it's contributing to it. But Michelle, what's been your experience?
Well, I just will speak to calling this the cottage industry. I think people say that about the plaintiff's bar in employment discrimination. But, excuse me, sorry. But what we see is it's a really important part of enforcing these laws. The private attorneys need to be incentivized to represent clients and bring these cases. And so in these statutes that have fee shifting, so if you prevail, you can get the other side to pay your attorney's fees and costs. That's important. And as I had mentioned earlier, under Title VII, we have very broad damages. And so the higher the value of the case, the more clients are being compensated well, but the lawyers are also interested in doing this work. And we kind of call that, some people refer to it as private attorney generals. because you don't have the Attorney General going into all these places. But if an individual can go sue their employer, go right to court, stopping at the EEOC, that's an enforcement mechanism. That's what's making the employers worried. And these broad damages, they're worried about that. If you can get emotional distress damages, those awards can be very high. And you can even have punitive damages if you meet a certain standard. So employers, when they calculate the risk of defending these laws, they are concerned about how costly it could be if they lose. And punitive damages, of course, can be sky's the limit. Judges often cut them down, but still, you don't know what's going to be done. So I think that's an important part, not necessarily, right. Because if no one was suing under these laws, then it's a little more like other countries that don't really have the enforcement mechanisms.
Why are you looking at me again?
Yes. And I think that when we look at movement, closing the gender gap, if you start from the 60s, when this legislation was first put in place, I think we've made a lot of progress, right? Yes, this gap does remain. There are many theories about that. I think you heard about, the child care issue. We don't provide that, and so somebody in the family has to make sure that they can cover the child care and the needs of their children in families, and usually that's the woman, because that's the way our culture is. And so they will say that women self-select into lower paying industries where they work part-time instead of full-time, and they take these gaps during which they may be raising young children. So I think there's been progress, big picture, but don't know how to close the gap.
All right. Daniel, I know you're dying to share with us the bad news over in the EU, right? What's been the impact that you've seen?
Well, we don't have any experiences with the new EU regulation because it only has to be transposed by all member states by the end of June 2026, right? But we do have experiences, of course, with the German statute of 2017. We have experiences with other European directives that have been imposed transposed in the member states, such as anti-discrimination directive and anti-discrimination laws. And what we saw there was first a big outcry of corporations and corporate lawyers saying, oh, that's the end of our economy and we'll have a plaintiff industries and so on and so forth. And apparently those cries were heard by the German government, at least, right? Because they made this law pretty ineffective. And the German courts didn't really do much to change that, because the awards they were actually given to plaintiffs were, I would say, ridiculous compared to what you guys are used to. So Michelle, maybe you can tell us what a median award in your practice is, or an average, or what was the top award you know of. And then maybe we can compare it with the awards we actually typically see, if we see any at all.
Yeah, I don't think I can do that. I don't collect data on it, but certainly they can range from $8,000 up to $1 million or more. A lot of smaller cases end up settling around 50, something in the higher five digits, and then it's the cases that are up in the millions or the upper six-figure digits tend to be for people that are high wage earners, and that's kind of just the way it is. Their back pay is higher, certainly. So, yeah, they can be very high awards.
That's interesting, because back pay is no remedy under the German law anyway. But the median award is probably, in my experience and from what I see in the case law, is probably like 5,000 euros, right? Typically, they award 2 monthly salaries, something like that. And the highest award was, and I only read this in the case law, was 50,000 euros. That's nothing, right, compared with what you said. And we have some other issues with enforcing laws via the private attorney general too, because German plaintiff lawyers cannot be incentivized by contingency fees. they are getting a flat fee determined by statute, and it doesn't matter whether they lose or win, right? So the statutory fee is typically not very high. And you know how it works with flat fees, right? You have actually also you got services on the basis of flat fees, and you can actually have your own. You will probably have your own experience whether you got an excellent service and whether somebody was really into it or not, and that's definitely a factor. And then we also lack some procedural tools that doesn't make it really spicy for plaintiff lawyers to go after big companies in terms of gender pay gap or other discrimination claims. So we don't have jury trials in German labor courts. In German civil courts, we don't have them either. So we don't have a tradition of jury trials. We don't have pretrial discovery, right? No interrogatories, no depositions, no whatever you guys have here on nice things. So I always have the impression
That's why the law schools look so shabby in Frankfurt.
I always think if I mention to a US client that we go to court with a case, or that this case goes to court, they want to pay me everything to make this go away and settle, right? Because they have no idea how cheap this is compared to the US, right? It's very simple, very straightforward, and you don't have to pay a lot of fees to their lawyers before you even go into court. That's definitely something, and then we have no kind of mental distress cause of action, right? I mean, we have it on the books, but as I said, no huge awards. So those are various reasons why it's not really sexy to actually go after employers for that. And yeah, that's so much about laws that look good on paper, but not very good on practice. And unfortunately, we have a lot of them. And actually, I'm being a little funny about it now, and I'm making fun of it, but it's actually quite concerning also if you think it from a big picture perspective, because the faith and the trust in the rule of law is not very great, right? If you have laws on the paper, nobody's enforcing. And people see this gap and this difference, and they wonder what's happening. On the one hand, employers should behave a certain way. On the other hand, they don't, and they get away with it. And that's a policy issue, but probably not something of your concern here now today.
Nikki, what about you from a data perspective? Because I know Michelle brought up data that she doesn't have it, but what have you seen as a result?
So from the IO perspective, what we've seen some of, and hopefully we'll see more of, is a more thoughtful approach to compensation decisions and analytics. So on the pay transparency piece, particularly in those states where there are requirements for posting ranges on job descriptions, that encourages the employers to be more thoughtful and pay more attention to their compensation philosophy in general and setting those pay ranges based on the actual requirements and responsibilities of that job and really focusing on what the pay is going to be for the job rather than setting the pay for an individual candidate coming in. And decisions like that, taking a more analytical and thoughtful approach to setting those pay ranges, helps to take out some of that discretion and can help mitigate some of the bias in those decisions. And then looking at the pay equity piece, what we really focus on with our clients when we're doing pay equity analysis is making sure that the analyses are done in a way that makes sense and actually compare people doing similar work so that the outcomes of those analyses are actually meaningful. So if you're relying on an existing set of job groups or job architecture in an organization, making sure that that's actually based in some sort of thorough, job analysis, understanding of the jobs, and that architecture actually distinguishes jobs that are similar based on those skills and effort, responsibility, and working conditions to say that these people are actually doing similar work, and therefore it makes sense to compare their pay together. And this is an area where occasionally employers will want to look at job title as a basis for this, and that's just looking simply at something like a job title really isn't enough to tell you this kind of information about a job, because you run the risk of, job titles that are common across different areas in an organization, something like an administrative assistant. They might be titled different things slightly based on the business unit that they're in or the area that they're in, or legacy titling, or for a lot of different reasons they might be doing the same job, but their title just looks a little bit different based on where they're sitting in the organization. And so you're missing grouping those people together in your analysis. Or you might have the flip side where you have the same job title encompassing a lot of different employees who in reality, when you start digging into the jobs and the responsibilities and the requirements, they're actually doing very different work and they're specializing in different areas that require different experience and maybe different education, but they're all titled under the same thing. And we see this often with something like software engineering, where everyone is titled a software engineer, but they're actually specializing and doing very different work and have very different requirements based on the job. But you would be capturing them all together in analysis based just on job title. So this is something that we really focus on with our clients, is really studying these jobs and making sure you have the appropriate groupings and the right altitude to actually analyze pay in a way that makes sense and is appropriate. So you can do this in an empirical, quantitative kind of way, and that's what I have a little bit shown on the screen. If you conduct something like a job analysis study and you actually collect data on what are the important tasks that are performed by the job. What are the knowledge and skills and abilities that are needed for the job? What are the requirements and the experience that's necessary for this job? And you can use this data to either kind of point by point, if you have two jobs that you suspect are similar or seem similar but you suspect they might be different, you can kind of point by point go through and do a job by job comparison based on this data. Or you can do overlap analyses based on a wide number of jobs and start to see where common patterns come into play, where there is a significant amount of overlap in the requirements of these jobs, and start to use that as a basis for grouping. This is an area, touching on our panel on AI earlier, where we have also brought in AI a little bit, where there are organizations that don't have a clear job architecture, but they have a lot of job postings and job descriptions, so we can use AI as a starting point to kind of sift through that amount of data and start to identify some of those areas where there might be clusters of similar jobs, and use that as a starting point then to then, of course, have human experts come in and review that data, and start to identify what are going to be the most appropriate ways to group the jobs in a way that makes sense to analyze them, because these considerations are really key in making sure that the analyses that you run actually yield meaningful results when you're analyzing pay across the organization.
So I'm just curious, we talked about generally, right, the gender pay gap, the racial pay gap, and those studies that we look at encompass, right, large numbers of employers and broad data. And the analyses that you've done, right, because I'm presuming it's for individual employers, have you seen any changes over time in the results of those analyses? So in other words, have you seen less and less flags, right, from employers across time?
So the reality is that there's always going to be flags, especially when you're looking at large employers. Even just statistically, the way that the analyses typically work generally, the more people you have, the more likely you are to find some sort of discrepancy. And that's where that importance really comes into play of understanding who you're analyzing and how and why, and making sure that if you're controlling for different factors, that those factors, things like performance ratings or tenure you might be controlling for in your analyses, making sure you really understand those as well, and that those are based on good data that you're pulling in there, and making sure that you have really strong compensation practices and philosophies and based on an understanding of the job that allows you to identify how and why compensation decisions were made if you are going in to more deeply evaluate the discrepancy or a flag that you're finding in the analysis.
Thanks. All right, so now let's turn our focus to 2025. All right, I'm going to take a real quick poll. Does anyone know what March 25th was? Anybody?
Equal pay day?
Good job. Lunch? It's on NYU. Oh. Good job. Yes, March 25th was Equal Pay Day in the United States, right? It's the symbolic date that highlights the gender pay gap, marking how far into the year, right, women must work to earn what men earned in the previous year, right? And in the past, right, I would suspect that I probably would have seen many more hands, right? Because we all saw press releases, right? Media coverage, it's all in the newspapers from the EEOC, OFCCP used to issue press releases, and this year kind of came and went without any fanfare. So, Michelle, what does that mean for us, right? The lack of news coverage, right, around that date this year, does that suggest that pay equity is no longer a thing?
I think that the reason we didn't have a lot of press coverage is because they were covering so much else of really important.
point.
But obviously, the new administration has put the focus elsewhere, or I should say, it is changing the way we look at pay discrimination or discrimination in general. The laws don't change, so you've got your attorneys representing clients. You go ahead and do that, and the judges are looking at the law and the court-made law, and an administration can't change that directly. But the executive has control over these agencies that would be the watchdog, the NLRB, the OFCCP, EEOC, and has various ways to change that, as well as issue their own executive orders, which they can, and the Trump administration has done. They issued an executive order 14173. It's different in that, there's a lot of this talk about everything being merit-based, without understanding that that's a subjective thing. And rescinding any affirmative action requirements. It has mostly shut down the OFCCP. They have very few employees left, and their job is just about enforcing the Rehabilitation Act, which is about disability, and protecting veteran rights in certain areas. The NLRB and the EEOC were made by statute, so it takes an act of Congress to change that or to rescind those laws, and that isn't likely to occur. But there are other ways to damage this enforcement mechanism, and that is by rendering these agencies toothless. And you do that by firing the heads, firing board members. You no longer have a quorum, and then appointing someone or not, but when you make appointments, having people that are carrying out what your directives are. So I think culturally, what the executive is doing is changing thoughts and analyses, but not the laws.
All right, Daniel, what can we expect to see in the EU in terms of today?
Well, that's, of course, remains to be seen. We have no idea so far how, especially in my country, the German statute will look like. That is meant to transpose the EU directive on pay transparency into national law. We did, as a law firm, but only unofficially, had a first glance at a first draft. That was somehow significant. I think the biggest difference in terms to the current situation is that there will be back pay claims available. And if the standard you have to meet to shift the burden of persuasion to the employer is extremely low, then even the dumbest lawyer working on a flat rate can actually make the employer have to demonstrate the whole thing and can actually also succeed. And if we then look at the statute of limitations, that must not be less than 3 years. You can imagine that probably people who are not in the employment relationship will probably not, people who are in the employment relationship with their employer will probably not sue the employer while they're employed. But you will probably see this a lot with people who leave the company and then sue, and then the maximum damage will be the gap between the salary they received for the last 3 years and the one they were supposed to, which will not be huge, but it will probably more than before, right? Will this change a lot? Yeah, maybe we can see a certain awareness that will grow under the new regulation, and if it is transposed effectively by the German government into law and by other European countries, will it change the whole landscape significantly in terms of gender pay gap? I have my doubts. I wish it would, but from what we can see, and this is actually similar to the data we received yesterday, is that especially childcare seems to play a big role still, and unfortunately, the regulation doesn't really tackle that issue. I mean, in Germany, we have a really special situation. We have had a reunification in 1990, but we're still not really one country, you know, mindset-wise. And you saw it in the eastern part of the country, that it was very, very common during the communist regime that women would work full-time, and there was a lot of daycare provided for by the government. And we had a different situation in the western part. And if you look at the gender pay gap in Eastern Germany, it's 7%. That's not nothing, but it's not huge. In the western part of the country, it's nearly 20%. And this whole tradition of and culture of mom and dad working full-time and daycare and sending kids already at an early age to the daycare, to the Kinderkrippe, we call it, already at 1 year and older. This probably makes a difference, right? And I think as long as we don't see a lot of progress when it comes to that, I have my doubts whether this regulation will actually do a lot. In Germany, we have a special situation. We even prevent parents from coming back to work. We incentivize parents from staying at home for at least 1 year per child. Why is that? We pay them, the German government pays them up to 2,000 euros per month per kid for 1 year to take care of the kid at home. So you get 2 kids, you stay at home at least for 2 years. Guess what parent stays at home in 90% of the cases? It's the women, right? And I'm not saying men are forcing them. In Munich, which is a very conservative Western German state and city, are pretty conservative. I don't see many women who actually want to come back to work before 1 year is over, right? That's at least my subjective impression from also our employees. So I think there's a lot to be done there, and it's not that difficult, but politically it's complicated. And I think the German government would be better to invest this kind of money by providing for sufficient childcare rather than paying it to the people. But, well, that's just me, and try to actually run an election on this platform, right? So this is probably pretty difficult.
Right. I'm not convinced, right, that we're going to see less enforcement by the EEOC, right, of pay discrimination under Title VII or the Equal Pay Act. I think we are likely to see, right, a different take on it, right, so that if an employer is making paid decisions, right, in advancement of diversity, equity, right, where a group is being favored to the exclusion or the detriment of a different group, perhaps the majority, I think that's definitely going to be a focus, right, of the EEOC. I'm sure you all remember the law firm letters, right, that were issued in March by the EEOC to, I think it was about 20 or so law firms, right, requesting information. Many of those questions involved pay decisions, right, that were based or born out of a DEI initiative or were made in accordance with a diversity fellowship, right, or internship. So I think it's just going to be a different look, right, which, look, this was all unlawful before this, right, before 2025. It has always been unlawful to make a pay decision or any employment decision based on a protected characteristic, right? That was always risky. Was the risk lower before this administration? Yes, right? The risk is higher now, but it's always been a risk. But Nikki, I'm just gonna ask you a real quick question, and we talked about, or the other panel talked about disparate impact. What about that executive order that basically is trying to ban the use by federal agencies of disparate impact? Does that impact or change at all how employers analyze, right, their pay if they're doing these proactive analyses?
Yeah, so, right, I'm not an attorney, so you will could give a much better explanation on where pay equity does or does not fit within disparate impact, but I'll say, in terms of the framework we use to analyze pay equity, that has not changed at all. The same principles that we would use prior to the executive order for how we would want to look and analyze pay, those stay the same. And we would certainly are continuing to encourage organizations to continue to proactively analyze their pay and have an understanding of what's going on in their organization, because we've certainly, still seen and been involved with pay equity claims coming from private plaintiffs' bar and under state laws, local laws. So it's certainly something that we would still encourage employers to take note of and still continue as a practice.
Good. All right. So I would venture to say, right, now the question on everyone's mind is like, now what, right? And what do we do now? Given what we've seen and faced with all the remains to be seen, right? What, if anything, should we be doing differently? Right? Well, there's that old saying, right? The more things change, the more things remain the same, right? I think one of the things that still remains the same, right, is that employers should have in place a strategy around compensation, right? And you need to be clear and consistent, right, and deliberate about that strategy. You need to evaluate your systems, know what you're going to pay your employees, right, and how you're going to pay them, right? And you're going to pay for the position, not for the person, right? You need to set salary ranges, make sure that's being applied consistently, right? If you're going to post these salary ranges in your job advertisements, you should check to make sure your incumbent employees holding those positions are within those, right? Your communication strategy also needs to be consistent, right? How much do you want to share? How much are you willing to share? Again, it should all be deliberate, right? And intentional and clear and consistent. We're going to talk, Nikki talked about doing pay analyses, right? If you have attorney-client privileged information, employers need to think about being deliberate about what to share, right? Because that privilege can be easily waived, but you should do it intentionally, right? If you are publishing your efforts and what you have done, right, and you've linked your efforts with respect to trying to achieve pay equity to DEI initiatives, I would go back and be deliberate and think about that. I'm not telling anyone to pull back from anything they believe in or that they want to do, right? You need to think about your company's business, right? Your risk tolerance, right? And your company culture. Because that phrase, right? Those letters, DEI, it's a lightning rod right now. So again, it just has to be very deliberate and intentional. And make sure the people involved in these pay decisions, right? Your hiring managers, your HR folks, your compensation folks, they know and they adhere to your compensation strategies, right? But above all, right, risk tolerance is always going to be part of your decision in that. And Nikki, coming back to you, right, given the administration's focus, right, on illegal DEI, right, should employers continue to analyze pay?
I'll shout it from the rooftops. Yes, we definitely would continue to encourage employers to conduct regular pay equity audits. Yes. And have an understanding of what the state is within your organization. And to a couple of the points that Joy made, there might be some additional considerations about how you conduct those analyses and what information you share, right? If you conduct it under privilege and keep it in-house versus if it's displayed publicly as part of a DEI initiative, that becomes a different conversation now. But in terms of making sure that you are still collecting this data and analyzing it on a regular basis to have an understanding of what's going on in the organization, we still would say that that's very important.
And Michelle, what about claims? How should we? Yes.
As far as a
we're just
plaintiff's
gonna
bar,
cover this, right?
we're just going to keep doing what we're doing. I think that there's consternation at the EOC, the NLRB, about what their directives are, what they can do, whether they have enough employees. But as far as the plaintiff's bar, we're just bringing our cases like we always have.
Right. I just want to give Daniel one last chance, and then we're going to take questions. I promise. One last point to make. What about global employers, Daniel? How should global employers, how do they reconcile, right, this administration's position on equity initiatives, right, illegal DEI, with the views over in the EU and what global employers are doing?
That's a tough one for me to answer, of course, because I'm not so much familiar with what employers, for instance, an American company doing business in Germany and applying the regulation and the laws, DEI laws, would actually face in terms of sanctions here in the US. Probably most CEOs will actually do an analysis and will decide on the basis what's worse for them, right? And given what I just told you about what you have to expect in terms of sanctions from a European perspective so far, I have to say, this decision and this analysis is not so difficult to make, I think, right? But again, I lack the knowledge of what companies here in the US would face, and I think you are in a better position, and everybody in this room, to answer this question. And again, let's see what the European Union and the member states do with the directive, and maybe then we have a better overview of what's happening.
Daniel, can I ask you a question? Do the labor courts in Germany or elsewhere not take seriously pay discrimination claims?
Not really, no, not really.
It's like a legal culture problem.
It's like a legal culture, and you have to also imagine many companies are bound by collective bargaining agreements, and the labor courts in Germany, they have a tendency to hold this concept of collective bargaining agreements up, right? They are in favor of it, they defend it, they sanction the employers who try to get rid of this, and they are very friendly in terms of employers who apply those collective bargaining agreements.
The courts would not allow departures from the collective agreement.
They do allow it, but they make it tougher where they can,
Gotcha.
for companies.
Gotcha.
They make our job tougher sometimes to actually allow companies to get rid of those. But of course, there are limits for the courts, but we have to understand that those collective bargaining agreements, they would probably not suffice under the standard provided by the EU directive, the new one, in terms of compensation schemes that are really preventing employers from discriminating against employees on the basis of gender. Why is that? Because seniority and years in service play a huge role in terms of compensation under the collective bargaining agreements, right? And there we are, back with on square one, so to say. And this is also why I think courts will be reluctant to be really tough on employers in terms of this directive, because it would mean to interfere with collective bargaining agreements a lot.
Thank you.
We have time for one question. If anybody has a question. Well, then please join me in thanking these wonderful.
Fantastic. Thank you.